Good morning to all of you. Now let's start today's discussion. Now today basically we are planning to discuss 2018 phase 1 like shift 1 question paper, in which like in the last class we have discussed till your question number 60. So from today onwards we have to discuss from question number 61 onwards, right? तो चलिए आज के डिस्कशन को हम लोग शुरू करते हैं। और अगर अभी तक आप लोगों ने हमारे चैनल को सब्सक्राइब नहीं किया है तो प्लीज जाके हमारे चैनल को सब्सक्राइब कर लीजिए एंड डोंट फॉरगेट टू प्रेस द bell icon, so whenever me or any of the faculties are coming live you will get the notification of the same. Now, and if you haven't checked out MP Civil Judge Prelims crash course, link is in the description box. Just do check it out. So question number 61, first question for the day, that is extrajudicial confession means a confession made. Extrajudicial confession means a confession made. Option A, before judicial magistrate in court. Option B, before doctor. Option C, before friend. And option D, both before doctor and friend. So what should be the correct answer? Extrajudicial confession means a confession made. Option A, before judicial magistrate in court. Option B, before doctor. Option C, before friend. And option D, both before doctor and before friend. So what should be the correct answer? Question number 61. Yes, what should be the correct answer? So they are asking which of the following can be considered as extrajudicial confession. So its correct answer will be D. Yes, Biniji, you are correct. Both before doctor and before friend, that is considered as extrajudicial confession. Next, question number 62. If an accused person, Ankita Gupta ji, you are also correct. 61D is the correct answer. Question number 62. If an accused person voluntarily consents for brain mapping and narco analysis, then such information is relevant under which section of Indian Evidence Act? If an accused person voluntarily consents for brain mapping and narco analysis, then such information is relevant under which section of Indian Evidence Act? Your options are section 7, section 17, section 27 and section 30. Option A, section 7, option B, section 17, option C, section 27 and option D, section 30. Yes, what should be the correct answer? Question number 62. Voluntarily consents for brain mapping and narco analysis, then such information is relevant under which section? Yes, Viniji, you are correct. 27, under section number 27. So C is the correct answer. Question number 63. Identification of a suspect by a photo is. Identification of a suspect by a photo is. Option A, not admissible in evidence. Option B, admissible in evidence. C, the suspect must be present. And option D, both not admissible in evidence and the suspect must be present. So identification of a suspect by a photo is option A, not admissible in evidence. Option B, admissible in evidence. Option C, the suspect must be present. And option D, both not admissible in evidence and the suspect must be present. Question number 63, that is talking about TIP, that is test identification parade. So test identification parade conducted by a photograph. So its correct answer will be 63. What should be the correct answer? Yes, 63 ka correct answer will be B for Bangalore. Yes, Ujjwal Nahar ji, you are correct. Vinny ji, no, D will not be the correct answer. Its correct answer will be B. As per section 9 of Indian Evidence Act, test identification parade can be done through a photo as well, right? Through showing the photo of the suspect. Now, nahi Ankita Gupta ji, 63 ka B is the correct answer. B for Bangalore. Question number 64. There is a charge upon A. Ujjwal Nahar ji, sorry, B. Okay. So there is a charge upon A committing murder at Kolkata on a certain day. He takes plea that on that day he was at Mumbai. the statement of A is relevant under which section of Indian Evidence Act? I think this particular question, question number 64, किसी का भी गलत नहीं होना चाहिए. This is quite common question. If you are having basic idea of Evidence Act, probably you will be able to answer this question. Your options are section 8, section 9, section 11 and section 14. So when A has been charged for committing murder of a person in Kolkata on a certain day, he takes the plea that on that day he was in Mumbai. The statement of A is relevant under, yes, it is relevant under section 11. So C is the correct answer. C for Calcutta is the correct answer, right? Now, next question. Question number 65. Question number 65 थोड़ा सा lengthy है. So I will suggest you all to take time to read this particular question. Don't create panic and then only answer the question. So the question is, a dying declaration is relevant under section 32 of the Indian Evidence Act, notwithstanding is being hearsay evidence. 64, Ujjwal Naharji is saying 8. I don't know what you are trying to convey, Ujjwalji, by writing 8 over there. So, a dying declaration is relevant under section 32 of Indian Evidence Act, notwithstanding is being hearsay evidence, because option A statement by a person as to the cause of his death is graded in law as the Solomon statement. Option B, if a person is dead and anything said by the person as to the cause of his death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit that statement. Option C, because it is believed that a person would not meet his maker with lies in his mouth. Option D, because society owes a duty to dead person to give him justice. So 65 ka what should be the correct answer? Yes. Now 65 ka ideally, if you will check the ideal answer key, they have written it C, but as per me C should not be considered as correct answer, right? Again, it is my observation, I might be right or might be wrong. As per me, its correct answer should be B, because if you will read section 32 and section 33 ka historic development, you will come to know that why the statement as a dying declaration is acceptable. The reason behind is pretty clear, that that particular person cannot be produced before the court for a cross examination and re-examination, right? So that's why it is relevant. So as per me, it should be a B, but if you people are saying C, I will accept C as well, right? Because they have given this particular question was disputed. Question number 66. The burden of proof in case of plea of alibi is, the burden of proof in case of plea of alibi is, option A, on the prosecution, option B, on the accused, option C, on the investigation agency, and option D, none of these. Burden of proof in the cases of plea of alibi. Burden of proof in the cases of plea of alibi is on option A, on the prosecution, on the accused, investigation agency, and yes, legal knowledge, you are correct. Its correct answer will be on the accused. As per section 103 of Indian Evidence Act, the burden of proof will be to prove plea of alibi will be on the accused. Viniji, you are also correct. Question number 67. The defense of alibi is governed by, the defense of alibi is governed by, option A, section 9 of Indian Evidence Act, option B, section 12 of Indian Evidence Act, option C, section 11 of Indian Evidence Act, and option D, section 6 of Indian Evidence Act. So defense of alibi is governed by section 9 of Indian Evidence Act, section 12 of Indian Evidence Act. Yes, legal knowledge, you are correct. Its correct answer will be C for Calcutta, that is section 11 of Indian Evidence Act. So section 11 of Indian Evidence Act talks about plea of alibi, right? Viniji, you are also correct. Question number 68. A witness may, while under examination, refresh his memory by referring to any writing made by him, made by himself, at the time of transaction or soon afterwards. The provision is provided under option A, section 160, option B, section 158, option C, section 166, and option D, section 159. So what should be the correct answer? They are simply, if I will ask, the question is refreshing the memory. This is something they want to ask. So what should be the correct answer? Question number 68. Yes, legal knowledge, Vinny ji, both of you are correct. Its correct answer will be D for Delhi, right? Now, let's move further. Question number 69. In the Indian Evidence Act, the conditions in respect of computer output to be deemed and admissible in evidence as a document is contained in Section 65B subclause 1, Section 65B subclause 2, Section 65B subclause 5, Section 65B subclause 4. Question number 69. So, the rules or the conditions in respect of computer output, they are given under which section? What should be the correct answer? Question number 69. Yes, Ankita Gupta ji, you are also correct with question number 68. Question number 69. What should be the correct answer? Yes, its correct answer will be B for Bangalore. That is under section 65B subclause 2. Because, so please answer question number 68 again. 68 ka D is the correct answer. Question number 68 was talking about refresh of memory. They were asking ki refresh of memory of witness is given under which section? In 68, and its correct answer was 159, right? Now, next question. Question number 70. Which one of the following is not a competent witness? Which one of the following is not a competent witness? Deaf, minor, mentally retarded, and dumb. Question number 70. Which one of the following is not a competent witness? Deaf, minor, mentally retarded, and dumb. So what should be the correct answer with question number 70? Question number 70, what should be the correct answer ideally? Can anyone tell me? Yes. Question number 70, its correct answer will be option C, that is mentally retarded person. So mentally retarded person is not a competent witness. Okay? Yes, Vinny ji, you are correct. If you will read your section 118 of Indian Evidence Act, section 118 आप पढ़ते हैं Indian Evidence Act का, तो you will come to know its correct answer will be C. Yes, Ujjwal Nahar ji, you are also correct. Question number 71. Under section 45 of Indian Evidence Act, opinion of the expert is. Under section 45 of Indian Evidence Act, opinion of the expert witness is. Option A is a conclusive proof, option B is not relevant, option C is not admissible, and option D is not a conclusive proof. So here they are asking, as per section 45, the opinion of the expert witness is, what is the value of that opinion of the expert witness? Conclusive proof, not relevant, not admissible, and not a conclusive proof. Question number 71, what should be the correct answer? Yes, D is the correct answer, Vinny ji. You are correct. So it is not a conclusive proof. Next, question number 72. Under Indian Evidence Act 1872, which one of the following is not essential condition for admissibility of dying declaration? Under section 32 of Indian Evidence Act 1872, which one of the following is not an essential condition for admissibility of dying declaration? Option A, the statement as to any of the circumstances of the transaction which resulted in his death. Option B, person making statement must be under expectation of death at the time of making such statement. Option C, death of the person making dying declaration is must. Option D, the statement must be as to the cause of his death. So question number 72. Now, what should be the correct answer of question number 72? 72. Yes, B for Bangalore is the correct answer. Vinny ji, you are correct. Now, if you people will actually find the difference between Indian dying declaration and British dying declaration. In British dying declaration, it is an essence that the person making a dying declaration must be under the expectancy of his death. But in India, it is not necessary. So as per section 32 subclause 1, B is the correct answer. Nahi Ujjwal Nahar ji, it will not be D, right? It will be B for Bangalore, right? Question number 73. Under section 27 of Indian Evidence Act, the fact discovered means. Under section 27 of Indian Evidence Act, the fact discovered means. Option A, the object produced only. Option B, the place from where the object is produced only. Option C, the knowledge of the accused as to the object and the place. And D, none of these, yeah, none of the above. As per section 27, the term fact discovered means. So, as per section 27 of Indian Evidence Act, the term fact discovered means, yes, the knowledge of the accused as to the place and the object. So its correct answer will be C for Calcutta. Question number 74. Yes, Vinny ji, you are correct with that. Question number 74. Under Indian Evidence Act 1872, for raising presumption, no, it will be C only, Vinny ji, not D, right? So, under Indian Evidence Act 1872, for raising presumption in respect of an electronic record, that the electronic signature on the electronic record which purports to be that of any particular person was so affixed by him, the record shall be option A, 3 years old, option B, 6 years old, option C, 5 years old, option D, 10 years old. So 70, yes, 73 ka Ujjwal Nahar ji, C is the correct answer. 74, what should be the correct answer? Now, if you people will read section 90A of Indian Evidence Act, you will get the answer of this question, right? In the previous class also, like when I was discussing 2019 question paper, at that time also we have discussed this. Its correct answer is C for Calcutta, that is 5 years. In the case of electronic document, in terms of electronic signature, the court may presume the genuineness of the signature in 5 years, and in cases of physical document, the genuineness of the document may be presumed after 30 years. So yaad rakhiyega 5 years and 30 years. Question number 75. Test identification parade conducted during investigation of a case is admissible in evidence under which section of Indian Evidence Act? So tip, that is test identification parade, is admissible under which section? Section 6, section 7, section 8, section 9. Question number 75. What should be the correct answer? Yes, Ankita Gupta ji, you are also correct. 74 ka C is the correct answer. Question number 75. Tip, that is test identification parade, is conducted during investigation of the case. So its correct answer will be under section 9. So section 9 talks about test identification parade, right? Now, question number 76. First question of Indian Penal Code. Under section 34 of Indian Penal Code, option A, physical presence is necessary. Option B, physical presence is necessary for participation but not in all cases. Option C, physical presence is not necessary. Option D, physical presence is necessary with common knowledge. So question number 76. What should be the correct answer? Yes, Ankita Gupta ji, 75 ka D is the correct answer. Question number 76. What should be the correct answer? As per section 34. What should be the correct answer? As per section 34, that is talking about your common intention, right? What should happen? Question number 76. Yes, B for Bangalore is the correct answer, Vinny ji. Right? Ujjwal Nahar ji, 75 ka D is correct. So, that is physical presence is necessary for participation, but not in all cases. Question number 77. Which one of the following option is incorrect? Question number 77, we have to find the incorrect statement. याद रखिए ऑप्शन ए क्या बोल रहा है? All murders are culpable homicide but not vice versa. Option B, all culpable homicide are murder. Option C, an intention to kill is not always necessary to make out a case of murder. And option D, clause C of section 299 requires the knowledge of probability of death. So question number 77, what should be the correct answer? We have to find the incorrect statement. 77, what should be the correct answer? Yes, क्या होना चाहिए correct answer for question number 77? Which of the following statement is wrong? Yes, option B for Bangalore, that is all culpable homicide are murder. So it is not the case, all culpable homicide are not murder. ठीक है, all murders are culpable homicide but all culpable homicide are not murder. Question number 78, Indian Penal Code. A lady wishes to get a railway ticket. Finding a crowd at the ticket window at a station, asks B, who was near window, to get a ticket for her. And yes, 77, Ujjwal Nahar ji, Ankita Gupta ji, it will not be A. A is correct and we have to find the incorrect statement. So the answer will be B. Yes, Ankita ji, it will be B. 78. A lady wishes to get a railway ticket. Finding a crowd at the railway station, asked B, who was near the window, to get a ticket for her and handed over him for money for the same. B took the money and instead of getting ticket ran away with the money. What offense has been committed by B? Option A, offense of theft. Option B, offense of criminal misappropriation. Option C, offense of criminal breach of trust. And option D, offense of cheating. So 78, its correct answer will be C, that is offense of criminal breach of trust. So it is a pure case of criminal breach of trust. What happened over here, that the lady entrusted that money. Lady handed over that money. So lady authorized that person to use that money for a particular purpose. So, and that particular person took that money. So its correct answer will be your criminal breach of trust, right? So 78C is the correct answer. Question number 79. A finds rupees 2000 note on a public road. He has no idea as to whom the rupees 2000 note belongs to. He picks up the note. A has committed. Option A, theft. Option B, dishonest misappropriation of property. Option C, attempt of theft. And option D, has not committed any offense yet. What should be the correct answer? A finds rupees 2000 note on a public place. He has no idea to whom rupees 2000 note belongs. He picks up the note. A has committed. Option A, theft. Option B, dishonest misappropriation of property. Option C, attempt to theft. And option D, A has not committed any offense yet. So the correct answer will be A has not committed any offense yet. Now, here you have to understand that A has no idea who was the owner of that property, owner of that rupees 2000 note. Okay, and they are not stating that A utilized that note for some purpose. A has here only picked up the note. So till now he hasn't committed any offense. But if he utilizes that money without making an effort to find the real owner of the property, then he can be held liable for dishonest misappropriation. So 79, its correct answer will be your option D, right? Now, this is a pure illustration of section 403. Question number 80, uttering obscene words near a public place. Uttering obscene words near a public place. Option A is not an offense. Option B is an offense under section 294 of IPC. Option C is an offense under section 290 of IPC. Option D is an offense under section 292 subclause 2 subclause B of IPC. Yes, Ankita Gupta ji. 76, you are answering B. Question number 76. Yes, B is the correct answer. Question number 80. Yes, Viniji, you are correct. Question number 80. Its correct answer will be B for Bangalore. That is section 294 is talking about uttering obscene words near a public place. Now, moving further, question number 81. To convict a person for offense under section 306. Option A, ingredients of section 107 of IPC are to be proved. Option B, the ingredient of section 107 of IPC not to be proved. Option C, mere cruelty is sufficient. And D, none of these or none of the above. So, firstly, you have to remember what section 306 of IPC is talking about. It is talking about abatement to commit suicide. So in the cases of abatement to commit suicide, what will happen? Ingredient of section 107 of IPC, that is talking about abatement, has to be proved. Option B is saying that the ingredient of abatement are not to be proved. C, mere cruelty is sufficient. And D, none of these. So yes, the ingredient of section 107 has to be proved. That means the ingredient of abatement that is under section 107 has to be proved. So 81 ka is the correct answer. Viniji, you are correct. Now, next question. Question number 82. In which of the following sections of the Indian Penal Code 1860 the punishment for wrongful confinement is provided? So which of the following section of Indian Penal Code provides the punishment for wrongful confinement? What should be the correct answer? The punishment for wrongful confinement is provided under which section? Question number 82. What should be the correct answer? Yes. Section 340 of IPC. Option B, section 341 of IPC. Option C, section 342 of IPC. And option D, section 350 of IPC. So which section talks about the punishment for your wrongful confinement? Yes. What should be the correct answer? Yes, its correct answer will be your option B, that is section 341. 341 is providing for the punishment for the offense of wrongful confinement. Question number 83. X extended to kill A, but instead killed B, whom he had no intention to kill. Under which doctrine is X is liable for the murder of? Option A, doctrine of extended malice. Option B, doctrine of mens rea. Option C, doctrine of diminished responsibility. And option D, doctrine of transfer of malice. So question number 83, what should be the correct answer? Doctrine of extended malice, doctrines of mens rea. Yes, Viniji, you are stating. So that is what is asked in the question. The punishment for wrongful, okay, wrongful confinement. So its correct answer will be option C. That is under section 342. Okay, the punishment for wrongful confinement is provided under 342. I misunderstood it as wrongful restraint. My bad. So question number 83. X extended to kill A, but instead killed B, whom he had no intention to kill. Under which doctrine X is liable for the murder of? Doctrine of extended malice, mens rea, diminished responsibility, and transfer of malice. So its correct answer will be transfer of malice, defined under your section 301 of IPC. Now, which section of Indian Penal Code deals with those conditions when the consent is said to be not free consent? So, question number 84. Which section of IPC deals with those conditions when consent is said to be not free consent? Option A, section 90. Option B, section 92. Option C, section 89. Option D, section 87. What should be the correct answer of 84? when the consent cannot be considered as free consent. 90, 92, 89, 87. What should be the correct answer? 90, 92, 89 and 87. Which of the following consent cannot be considered as free consent? So what should be the correct answer? Yes, under section 90, that is option A, Ahmedabad is the correct answer. So under section 90, a consent given cannot be considered as free consent. Question number 85. For offense of kidnapping from lawful guardianship, the age of girl must be. For offense of kidnapping from lawful guardianship, the age of girl must be option A below 18 years, option B below 15 years, option C below 21 years, and option D below 16 years. Yes, under section 361 of IPC, kidnapping from lawful guardianship, the age of girl must be 18 years, 15 years, 21 years, and 16 years. What should be the correct answer? 85. No, the age of girl should be below the age of 18 years. Viniji, its correct answer will be A, not D. Remember over here that in cases of kidnapping from lawful guardianship, the age of a boy, age of a male should be below 16 years. And in case of female, it is below 18 years. So its correct answer will be A, right? No, Ankita Gupta ji, its answer will not be D. It will be A. Right? Question number 86. थोड़ा सा lengthy question है. Give some time to read this particular question and then answer. The right of private defense of body. The right of private defense of body, option A, commences as soon as reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense, and it continues even after the apprehension ceases. ठीक है? Option B, commences only when the assault is actually done and continues during the period of assault. Option C, commences only when the assault is actually done and continues even after the offender left. Option D, commences as soon as the reasonable apprehension of danger to the body arises from an attempt or threat to commit the offense, and it continues as long as the apprehension of the danger to the body continues. What should be the correct answer of question number 86? Yes, 86, Viniji, you are correct. D for Delhi is the correct answer. That in the cases of right to private defense, it commences or it starts as soon as the reasonable apprehension to the danger of body starts, and it continues till the time such apprehension or danger to the body continues. Next question, question number 87. Which of the following statement is correct? Which of the following statement is correct? Option A, abator's liability is dependent on the liability of principal offender. Option B, if the abator is innocent, the principal offender is also not liable. Option C, abator and principal offender may be differently liable for different offenses. Option D, the principal offender must have the same guilty mind as of the abator, as that of the abator. So question number 87, what should be the correct answer? Question number 87, हाँ जी बताइए क्या होना चाहिए इसका आंसर? Which of the following statement is correct? Abator's liability is dependent on the liability of principal offender. If the abator is innocent, the principal offender is also not liable. The abator and principal offender may be held differently liable for different offenses, and the principal offender must have the same guilty mind that of the abator. So its correct answer is C for Calcutta. That means that the principal offender and the abator, both of them can be differently liable. Question number 88. Which of the following amounts to defamation? Which of the following amounts to defamation? It simply means आपसे ये पूछा जा रहा है कि जो defamation के 10 exception है उनमें से कौन सा एक exception नहीं है. This is what is question number 88 about. Option A, to convey a cause intended for good of person to whom conveyed or for public good. Option B, to make an imputation concerning a company or an association or collection of persons as such. Option C, censure passed in good faith by the person having lawful authority over others. D, publication of reports of proceedings of the court. So 88, what should be the correct answer? Yes, 88 का क्या होना चाहिए? Ankita Gupta ji, you are correct. 87, C is the correct answer. Vinny ji, 88, B for Bangalore is correct. Yes, you are right. B for Bangalore is correct. Now, next question, question number 89. Whoever kidnaps or abducts any child with intention of dishonestly any movable property from the person of such child shall be punished under section 369 of IPC if the child is under option A 10 years, option B 12 years, option C 14 years, option D 16 years. So if what is the child what is the age of child under section 369 of IPC? Like whoever is kidnapping or abducting a child with intent to taking or dishonestly taking any movable property from such child, if the age of child is under which age, so then it can be considered as an offense. So under section 89, what should be the age? 10, 12, 14, 16. It is 10 years. 89, A is the correct answer. So 89 ka correct answer will be A. If you will read the language of section 89, it is section 369, it is stating that the child under the age of 10 years. Okay, its answer is A. Okay, not 12 or 16 years. This time both of you are wrong, Ankita ji, Vinny ji. Now next question, question number 90. According to Indian Penal Code, any man who monitors the use by a woman of the interest नहीं होगा यहाँ पे, word will be internet, email or any other electronic communication. This is not interest, this is internet, email or any other form of electronic communication commits the offense of option A voyeurism, option B stalking, option C watching, option D searching. Voyeurism, stalking, watching, searching. Question number 90. What should be the correct answer? 90. A will not be the correct answer. What you are saying, Ankita ji, right? Its correct answer will be B. Okay? B, that is stalking. Voyeurism is clicking the pictures of private parts of a woman or private moments of a woman. And stalking is continuously tracing our women through direct or through some electronic media. So its correct answer will be B for Bangalore. That is stalking, right? So Ankita ji, Vinny ji, it will not be voyeurism, it will be stalking, right? So B is the correct answer. Now, just want to know one thing from you people. If you people just let me know what you people expect more from our end. Like what you are expecting, that apart from discussing this question paper, what else you require from us for your MP Civil Judge preparation, right? What you expect, what you are expecting कि ये और होना चाहिए with these classes. Just let me know in the chat section, ठीक है? And अगर यहाँ तक आ ही गए हैं तो don't forget to like the video and to subscribe to the channel, ठीक है? And usually I notice is कि there are numerous of students who attend throughout the session but they don't put a like button. So if you are attending the session, finding it informative, don't forget to press the like button, ठीक है? Still I am waiting for if any one of you want us as a team of Rostrum Legal to put forward more, something more for you people. Just let us know how we can help you more, right? Anything which you are expecting from your end that this should be there, okay, with the classes of past year question paper or like something new you want, right? Just let me know. And don't forget to check out MP Civil Judge Prelims crash course. Link is in the description, okay? Thank you Ankita ji. This is going to provide you recorded video lectures, 10+ mocks, mentoring and doubt clearing sessions, one-on-one interaction. So these things are going to be, sir, rapid revision. Vinny ji, you want a rapid revision. Okay, so that can be think of. Okay, done. Anyone else looking for something else? Sir, limitation important articles. Oh, I'm really sorry, Vinny ji. I forgot it yesterday. Tomorrow for sure I will give it to you. Right? Tomorrow for sure I will give it to you. I forgot to check it out. Yesterday was a slight busy day for me. Okay, Ankita, revision with major and minor subjects. For sure, after this, we are going to keep the revision of important sections of major and minors. And definitely when we are doing the revisions, we can also discuss the important sections. Right? Now, as of now, I can tell you one thing, looking into the previous trends of question papers, there is nothing like important. Okay? So we have to follow up the whole Bear Act. Yes, there are some of the provisions which you have to understand more conceptually, but there is only one way to crack your prelims, that is to solve past year question papers, solve as much MCQs as much as you can. Third, follow up the Bear Act, and third one should be considered as first one. थर्ड इज एसेंशियल, जो तीसरा पॉइंट है ना, फॉलो द बेयर एक्ट. बेयर एक्ट को आप जितनी बार मगअप कर पाएंगे उतना बेहतर है, और केवल रीडिंग नहीं करनी है, ट्राई टू कनेक्ट विद द कंसेप्ट. कोई भी सेक्शन वहां पे है तो क्यों है, राइट? अगर ये सेक्शन यहाँ पे नहीं होता तो क्या होता? दिस इज हाउ यू हैव टू अंडरस्टैंड, राइट? सो आई विल सजेस्ट एज ऑफ नाउ फॉर प्रीलिम्स, just focus on your bare acts. That is the one thing very much required. Second, try to practice as much questions as you can. Okay? And third, past year question papers. Right? Anything else? Okay. So this is how we are going to stop here for the day. Now we are going to meet tomorrow with some more discussions, with more interactions. So meanwhile, take care. Bye bye, all of you.